and welcome to PubK's 2022 Government Contracts Annual Review. We're thrilled to have almost over 1,000 registrants for the program. Welcome to, over the next 4 afternoons, we'll present 9 additional sessions with over 35 presenters and almost 15 hours of additional content. We hope you'll be able to join us for most, if not all, of these sessions, but a separate registration is required for each session that you want to attend. You can get that link on the PubK Annual Review website. I'm Alan Schwatkin. I'm the president of PubK Group and a partner in the law firm Nichols Lew. I'll be your host, facilitator, and moderator, and maybe occasional agitator for this year's annual review. And I hope that next year we'll be able to convene in person. The PubK Group consists of 3 newsletters: PubK Law, PubK Compliance, and PubK Cyber. Many of you are already subscribers to one or more of these publications, and we very much appreciate your support. Some of you joining this annual review are not yet subscribers. I hope you'll consider becoming a subscriber. Information is at the website shown on the slide or is available from any of the contacts you have at the PubK Group. This conference would not have been possible without the strong support of our event sponsors, all of whom are listed on these next 2 slides. I encourage you to look at the skills and the capabilities that these firms have. In lieu of speaker gifts and in honor of our sponsors, PubK is making a contribution to the Capital Area Food Bank. With the food crisis facing our communities, including the military, and here in the Washington, D.C. metropolitan area, I hope you will consider making an individual or an organizational contribution as well. Since the entire program is being held virtually, all attendees will be in listen-only mode. Your video will remain disabled throughout the session. But we still welcome your questions. Use the Q&A box at the bottom of your screen. However, with so many attendees, it's probably not possible to answer all of the questions in real time. We're capturing your questions, and we'll do our best to get you answers before the end of the session, not this individual session, before the end of the annual review. Nevertheless, all presentation slides, along with the audio, will be available for download from the PubK Group website, probably within a week or so of the conclusion of the full annual review. We'll send an email when the information is available for download, how to access it, and how long the material will be available. We're also applying for continuing legal education approval in a number of jurisdictions. While we can't guarantee approval, we expect that acceptance within the next few weeks. Again, we'll notify all attendees when those approvals have been received. And finally, if you're interested in obtaining CLE, please look for our poll question during the presentation. Probably do one during each of the 2 hours of this, during each hour of the 2 hours of this session. State boards require us to verify your participation during the event. The poll is a simple yes/no question. We'll keep track of the responses to verify that you viewed the panel. If you don't wish to obtain CLE credit, you can disregard the poll or just answer for fun. Now I'm thrilled to continue the 7th PubK Annual Review with our Session 3 panel on labor and employment. Our distinguished panel members are Nicole Atala from Polera Mazza, Richard Arnhold from Bassberry and Sims, Michael Schreier from Hush Blackwell, and Howard Wolf-Rhoda from Abraham's Wolf-Rhoda. Howard, over to you.
Thank you, Alan. It's appreciate you all putting on this panel, and it's great to be a part of it. And thank you to everyone for listening in. We hope you get some good content out of this. The topic I've been assigned to talk about today is the newly issued minimum wage executive order and the rules that have come out since that time for government contractor employees. This order, which was issued by President Biden on April 27th of 21, is basically an update of the executive order that was signed by President Obama in 2014. Both of those require contractors to pay at least an established minimum wage to workers performing work on or in connection with certain covered federal contracts. Under the Obama executive order, the original rate was $10.10 per hour. It's currently $11.25 per hour as of the first of this year. For tipped employees, there's a separate minimum wage of $7.90, obviously, plus tips for them, for waiters and waitresses type employees. The new rate under the new executive order will be $15 an hour and $10.50 for tipped employees. Now, like the old order, the new order will be increased year by year according to the Urban Wage Earner Consumer Price Index. The tipped wages, this is a new feature of this executive order, is going to be rather rapidly increased over the next few years until it actually equals the minimum wage for all other employees, and that'll be accomplished by January 1, 2024. Next slide, please. As I mentioned at the outset, the executive order applies to individuals who work on or in connection with a federal contract. So what's a federal contract? Okay, many of us are in procurement law. That's naturally one of the kinds of contracts. It includes, though, any agreement between two or more parties creating obligations that are enforceable or otherwise recognizable under the law. The term contract can mean, a contract within the meaning of the Federal Acquisition Regulation or applicable statutes, but it also is interpreted more broadly to include a wide variety of contractual arrangements, whether negotiated or advertised. So for example, it also applies to certain lease agreements, cooperative agreements, some intergovernmental service agreements, licenses or permits. In addition to bilateral instruments, the definition includes awards and notices of awards, job orders or task letters issued under basic ordering agreements, letter contracts, et cetera, et cetera. The types of contracts that are covered include service contracts, contracts that would be covered under the Service Contract Act, for example, construction contracts such as those that would be covered by Davis-Bacon. However, construction contracts that are funded by other statutory authorities, say, for example, housing construction contracts for Section 8 housing, those are not covered by the new wage. So if it's a related act as opposed to Davis-Bacon, it's not covered. Concessions contracts are covered. Some of them had formerly been excluded from coverage during the Trump administration, but this order applies to all of them. Other types of contracts include contracts in connection with federal property or lands, related to offering services for federal employees, their dependents, and general public. Next slide. One quick note before I jump into this content, just there is a dollar threshold that is $2,000 for contracts subject to the Davis-Bacon Act, $2,500 for contracts subject to the SCA. And I mentioned that, and a number of other things are going to be coming up. A lot of this can sometimes feel like a Venn diagram. Some things will be covered by the minimum wage executive order. There are other kinds of contracts covered by the sick leave executive order. The SCA applies to service contracts. And the reason I mention all of this is that you have to be mindful of what obligation you're talking about to figure out whether or not your contract is covered. But more on that in a minute. It applies to workers who are working on or in connection with these contracts. For example, if you're working on the contract in terms of doing the services that are called for, say in the statement of work, that will be working on the contract and usually is relatively easy to spot. What is less difficult, and in fact, even after several years of the minimum wage executive order and the sick leave executive order, contractors have difficulty with the notion of in connection with. So those in connection with, if you're working in connection with the contract, your work is necessary to the performance of the contract, although you're not necessarily working on the contract. A good example of that is people who work in the payroll department who process the payroll for the service contract employees. Another example is a security guard who is not doing construction work, but protects the site at which the construction is occurring in order to protect materials. So in connection with can reach out into a lot of areas that some contractors have not thought of. Now, that's no change from the Obama executive order. It's just that now things are a little bit more clearly defined in the definitions themselves. Now, there are tracking challenges posed here. And by tracking challenges, I mean, if someone is working half-time on a contract, but the other half is working on commercial work, the minimum wage applies to the time that individual is working on the contract. Same thing with in connection with. If they're working in connection with the contract for half the time, just to pick a number, but the other half of the time they're not, they won't be covered. Now, if you are going to pay these people different rates, you have to have very good records to demonstrate what time was devoted to one contract as opposed to your commercial work. The Act also excludes people who spend less than 20% of their time or less working on or in connection with the contract, but that again poses the same problem. You have to be able to track. If you don't track effectively, Department of Labor, if it comes in and reviews what you've done, they might say, you know, sorry, the higher rate applies. All right, next slide, please. The new clause is coming out. Well, actually, the FAR Council's deadline is today to produce the new contract clause that will be added to contracts to implement this executive order. A new contract is defined as new solicitations or awards. Something that's different in this particular executive order from the Obama executive order is that a new contract will occur when an option is exercised under an existing contract. Another sort of, I'll say, quirky situation is related to orders. Orders that are done under basic ordering agreements or blanket purchase agreements that are not subject to multiple award contracts. If an order is issued under one of those vehicles, that'll be a new contract. However, if you have a multiple award contract, for example, like a GSA schedule contract or an IDIQ contract where you get individual task orders, those orders will not be covered by the new executive order unless and until there is a modification to the larger contract instrument. So that could mean that with respect to GSA schedule contracts, it could be quite some time before the executive order will be applicable to task orders under your schedule contract. Next slide, please. During this period in which there's a transition from the old executive order to the new executive order, the regulations for the two executive orders are going to exist side by side, so that if you have contract A subject to the new executive order, it will be covered by the new regulations, and your contract that hasn't been modified yet could still be covered under the old executive order to the extent that it's already covered. Compliance is not required until the clauses are in the contract. Now, having said that, the new executive order, the wage determinations that are coming out for service contracts are having some rather odd wording, and bear with me while I pull it up for a second. There's language in the wage determination that says if the contract was awarded after January 30, 2022, or the contract is renewed or extended on or after January 30th, 2022, The contractor must pay all covered workers at least $15 an hour, or the applicable wage rate listed on this wage determination if it is higher, for all hours spent on performing on that contract in 2022. And I will tell you, I've already gotten a question is, wait a minute, if it gets added in December of 2022, I have to go back and pay all those wages? No. Our reading of it is that it only applies once it's in your contract. Next slide, please. So to my mind, the biggest change in the executive order is frankly that the rate increase that is occurring. There are some differences in terms of coverage, but by and large, the biggest problem that people are going to have is that the wage rate is now $15. Why is that a problem? That's because under the old executive order, the vast majority of SCA covered positions, for example, the prevailing wage under the SCA exceeded the minimum wage. So many contractors simply didn't need to worry about it. They'd look at their prevailing wage rate, see there was more than minimum wage rate, and just move on. That's not going to be the case anymore. Many places, the majority of wage rates, 50% or more, are going to be below this new minimum wage. So wage classifications in, say, rural areas that have a fair number of wages that are below $15 an hour, your contractor clients are going to have to be mindful of that and perhaps grant raises to those people where they wouldn't have before. Like I said, the rate will be pervasive. The other thing that could occur here is more in the nature of a business judgment decision is what is that going to do to your workforce? If some people are being raised up to new levels, are you going to need to move your employees up to account for the increased wages? I think there is some sort of policy hope in the background that it will. That intent isn't lost on me, but it will be something to account for. Also, there'll be wage compression in the wage determinations under either the SCA or Davis-Bacon. Those will be pushed up accordingly. However, that will take a couple of years to actually take place. So again, this process of having to keep track of what wage rate is applicable will be something to be concerned about. Next slide, please. So compliance going forward, as I've been touching on these rates, you need to make sure that your wage rate you're paying is either the higher of a prevailing wage in a wage determination or that it is at the minimum wage rate. But that's not the only minimum wage rate you have to keep your eye on. There might be state and local minimum wage rates that could surpass this new $15 an hour wage rate. I haven't seen any that are in excess of $15, but there are plenty right now that are $15 per hour, and they could be moving up. Another compliance issue that you need to keep track of is who's doing what. As I mentioned before, some people will be covered because they're working on the contract. Other people will be covered because they're working in connection with the contract. And you have to, again, keep track of what they're doing and when, because record keeping, as I say on the slide, is critical to being able to establish what rates you did pay and what rates you should pay and whether or not you're in compliance. Finally, there will be a process of price adjustments that will be allowed. The old contract provision allowed for price adjustments for the increased costs of compliance with the contractor minimum wage rate. I would expect that the new FAR clause that's coming out will likewise have a price adjustment provision. So you should be able to recover increased costs of complying with the new minimum wage rate. In conclusion, like I said, there is not that much new in terms of coverage and applicability. but the new wage rate is a significant change, and ultimately a disciplined approach to compliance will be more important than ever. Next, I'd like to hand off the microphone, if you will, to Michael Schreier to do a presentation. Next slide, please, by the way. On non-displacement of qualified workers under service contracts. Michael, you there?
I'm here, Howard.
All right, take
Thank
care.
you, Howard. Thank you. All right, folks. So, yep, I'm here to talk to you today about the brand new Executive Order 14055, non-displacement of qualified workers under service contracts. And, this doesn't apply to Davis-Bacon Act. This doesn't apply to other types of things. It only applies to service contracts. So, next slide, please. This is a little bit of what's old is new again. The Biden administration issued this executive order just about 2 months ago, in mid-November. And curiously, the sole authority for issuing this executive order is under the Federal Property and Administrative Services Act, which I suspect that we'll hear about later in the vaccine discussion. But I don't think that the Federal Property Administrative Services Act expressly authorizes the president to dictate hiring and firing decisions of private contractors, but we'll let the courts handle that one. So moving forward, this new executive order is basically a rerun of the Obama era executive order, 13495. And it's almost word for word the same, but with some new and important twists. But basically, for those of you who aren't labor and employment law geeks, the basic takeaway from this executive order is that successor contractors must offer a right of first refusal to all service employees working for a predecessor contractor on Service Contract Act covered contracts. And for right now, all we have is the executive order. Regulations are coming, but so here's what we know right now. So just to give you sort of, again, the background flavor for what's going on, for those of you who are relatively new to this, let me read a little bit from the executive order itself on the stated policy for this executive order. It says, quote, when a service contract expires and a follow-on contract is awarded for the same or similar services, the federal government's procurement interests in economy and efficiency are best served when the successor contractor or subcontractor hires the predecessor's employees, thus avoiding displacement of these employees. Using a carryover workforce reduces disruption in the delivery of services, yada, 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 yada. So those are the overall policy justifications for this. All right, let's go to the next slide. So before we talk about the ins and outs of this new executive order, let's talk about the coverage, because that could be an important issue. Specifically, it covers contracts, and it's defined as any contract-like instrument, or subcontract for services that is covered by the Service Contract Act. So the coverage for this executive order is expressly tied to Service Contract Act coverage. This new executive order is a little different because, as you see here on the slide, the old executive order only applied to any contract or subcontract and not to contract-like instruments. So it's an attempt to expand the reach of the coverage of this executive order beyond what the original EO said. Importantly, the coverage is intended to apply to both prime contractors and subcontractors. Let's go to the next slide, please. There are a couple of exclusions from coverage that are notable. First, contracts under the simplified acquisition threshold are expressly excluded by the language of this executive order. Similarly, employees hired to work under both a federal service contract and one or more non-federal service contracts as part of a single job are excluded. This is all sort of, you dip in water, you can read it at home in section 5 of the executive order. This particular provision is more or less in line with what was said in the original executive order, but it remains to be seen how Department of Labor will expressly define this and how far they will try to expand that or contract that exclusion from coverage. Next slide, please. Now, the executive order itself gives a verbatim contract clause that the president wants included in all covered contracts. It's set forth in full in section 3 of the executive order. I'm going to kind of go clause by clause to explain to folks what's going on here and what the impact is. So again, in conformance with the policy, clause A of the contract clause requires successor contractors to make a good faith offer of employment or right of first refusal to all SCA covered service employees from the predecessor contractor and its subcontractors. And importantly, the successor contractor and subcontractors cannot make offers of employment to any new employees, somebody who didn't work on the predecessor contract, before complying with the executive order. That's written right in there. So it ties the contractor's hands as they have to go to the predecessor's workforce first to find employees to work on this. Also, it requires the successor contractor and subcontractors to make an express offer of employment and give the predecessor employees no less than 10 business days to accept the offer. So as you can see here, the requirements pose some administrative burdens and hurdles for successor contractors to ensure that they make the right offers and give sufficient time for employees to be able to respond before the successor contractor can use its own workforce or go out to the market to get additional employees. Next page, please. Now, again, section B here, it makes it clear that successor contractors are not required to offer a right of first refusal to any service employees not covered by the Service Contract Act. Again, for Service Contract Act coverage, we could spend an awful lot more time, but sort of the short strokes of that, typically think if they're FLSA exempt type employees, then they are probably not covered by the Service Contract Act. Mostly think FLSA non-exempt as folks covered by the Service Contract Act. Now, the next bullet point here is where things start getting a little different between the new executive order and the old one. Under the new executive order, successor contractor is not required to offer employment to any employee whom the contractor reasonably believes, based on reliable evidence of the particular employee's past performance, that there would be just cause to discharge the employee. Let that sink in for a second. That basically there's a just cause requirement built into this. The old executive order simply gave the successor contractor discretion to not extend offers to predecessor employees who, quote, failed to perform suitably on the job. So it has now gone from the basis of a performance standard under the old executive order to now sort of a termination clause, a termination standard, whether there's just cause. So clearly, the administration is trying to tip the scale much more in favor of the employees and make it harder for successor contractors to pick and choose which employees will work on the contract going forward. Let's go to the next page, please. All right. So in addition to the hiring and certified offer and right of first refusal requirements, there are also paperwork requirements on both the predecessor and the successor contractor. The predecessor here will have a contractual obligation not less than 10 days prior to contract completion to provide the contracting officer with a certified list of names of all prime and subcontractor service employees working during the last month on the contract. And that list not only has to include the names, but also the SCA anniversary dates for computation of vacation and other fringe purposes. And then finally, under this clause C, the contracting officer shall provide the list to the successor contractor. And also the lists may be requested by employees or their representatives. A couple things about this. First off, under the prior executive order, relatively frequent that the predecessor contractor wouldn't put the list together and leave the successor contractor sort of in the lurch. And the new executive order didn't do a whole lot to fix that. But more importantly, given the express contractual obligation of the government to provide the list to the successor contractors may have a little bit of leverage to condition compliance of this executive order on receipt of that certified list from the predecessor. Now, the other piece about all this, full disclosure, once upon a time, I was in-house counsel to a labor union. So I'm reading this last bullet point as clearly giving insight to unions for organizing purposes, and also to plaintiffs' counsel for possible claims, FLSA claims, other class action claims. So it may very well turn into a ready source of referrals for unions and plaintiffs' counsel. Next page, please. All right, the next contract clause is contract clause E, as in Edward, and it's basically the flow down requirements. The prime has to flow down the requirements of clauses A, B, and C to the sub, and the sub has to flow it down. In addition, much like the original executive order, the prime contractor may be required by Department of Labor to take certain enforcement action against subcontractors if Department of Labor were to find violations. Again, because there's no contract privity between the sub and the government, we have to sort of follow the chain of contract privity down, and the prime or some tier of subcontractor will have to enforce this clause on the lower tier sub. And to the extent that enforcement by the contractor requires any sort of litigation or invokes any litigation with the sub, the contractor may request the government to enter any litigation with the subcontractor regarding the enforcement. Next page, please. So up to now, everything's been about what you need to do. When I talk to clients, the next piece is sort of the so what? Why do I care about this? Well, why do I care about this is non-compliance can result in some rather unpleasant penalties. And for those who want to follow at home, I recommend you look at Section 8 of the executive order. But among the remedies in the contract clause, Section D of the executive order, it says the sanctioned remedies including but not limited to orders requiring employment and payment of wages lost. So to the extent that a successor contractor does not hire predecessor employees, they may be required to do so and pay rather large back wage amounts, depending on how long after the succession of the contract occurs. Next, there is potential for up to 3-year debarment for willful violations of the executive order or a failure to comply with Department of Labor orders regarding compliance with this executive order. And again, most of this is pretty much on par with what the original executive order said. However, where things get a little interesting here is under the new executive order. It says that the contractor has the opportunity to present information and argument in opposition to a proposed debarment. The old executive order says that the contractor has a right to a hearing and related due process. So it's very interesting to note that in the new executive order, there is no explicit right to a hearing or to extensive due process for a contractor who is alleged to have willfully violated the executive order and is facing debarment. Again, this suggests a deliberate cutback of due process rights for contractors and a curtailment of due process rights, suggesting that the government wants to exert more leverage over contractors. Next slide, please. Another new aspect of the new executive order is this location continuity aspect. This was not in the prior executive order, but this is new. And again, quote, the agency shall consider whether performance of the work in the same locality or localities in which the contract is currently being performed is reasonably necessary to ensure economical and efficient provision of services. That wasn't there before, so they're trying to tip the balance in trying to ensure that the work is performed in the same location to make it easier and more justified for successor contractors to use the same workforce. And if the agency comes out, yes, that there is a reason to have it being performed in the same location, then the agency, quote, shall include a requirement or preference that the successor contract be formed in the same locality. Again, this is a new concept that was not in the original executive order. Fortunately, there is express language in the executive order stating that nothing in the executive order requires an employer or contractor to pay employee relocation costs. So, to the extent that the work does move to a different location and the contractor is required to make an offer of first refusal to predecessor employees, there is no requirement under the executive order, at least, for the successor contractor to pay any relocation costs. Next slide, please. Now we're getting into the nitty-gritty here a little bit about the executive order grants agencies a power to create exemptions from executive order coverage for very narrow grounds. There is a process by which contractors could ask the agencies to make those exceptions, but from experience and given the current flavor of the current administration, my personal opinion is that it's going to be unlikely for any executive branch agency in the current administration to grant any exceptions from the executive order now, particularly in light of the second bullet point here, where to the extent agencies are required to publish exceptions that are granted, and then requires contractors to notify effective workers and their collective bargaining representatives of the existence of any exceptions, almost inviting them to push back with the agency and to try to get those exceptions rescinded. So given the way this whole system works out, there needs to be some very high level overriding policy reason to grant an exception. Otherwise, for routine stuff, probably, again, my opinion, probably wasting your time to the extent you were going to ask an agency to try to grant an exemption here. Next slide, please. So for right now, all we have is just the executive order. The executive order directs the Department of Labor to issue final agency regulations no later than May 17th, 2022 on how to implement the executive order. So we're a long way off that. There's a good chance that it'll be largely similar to the old Obama era regulations, but we're going to want to make very careful analysis of those regulations, especially given the changes that I've flagged here today. There may be some very substantive changes about how the scales tip more in favor of employees and a little bit more against contractors, in defending contractors being able to defend themselves for perceived violations. And then the FAR Council is directed to amend the FAR within 60 days of Department of Labor issuing final regulations. Again, looking at the calendar, we're probably talking no later than July 15, 2022. So we're a long way off from when all these regulations are going to be issued. However, Section 11 of the executive order says that the executive order is, quote, effective immediately, and that the agency may start applying the contract clause in the executive order now, before the FAR Council issues its clauses and regulations. It gives agencies discretion. They're not required to do so, but would definitely be on the lookout now for some eager federal agencies to start trying to slip in the clause going forward. But once use of the clause will become mandatory once the FAR Council acts by around July 15th. At that point, then inclusion of the new contract clause will be mandatory. So the big takeaways from all this today is that this is coming. We see what the clauses are, and to the extent that you are or you represent contractors who are likely to quickly become predecessor contractors, should start planning now for gathering the information for the certified list of employees and anniversary dates that you may have to produce to the contracting officer. But more importantly, the burden on potential successor contractors going forward to start planning for how to roll out rights of first refusal letters, offer letters to predecessor contractor employees, and otherwise start complying with the requirements. But until we see what the final Department of Labor and FAR regulations and clauses look like, we would only be guessing right now to get the full extent of the obligations. But I think based on what we've seen so far in the executive order, we all have a pretty good idea. So that is the non-displacement. And I believe the next eager volunteer is Nicole.
Hi, everyone, and thanks, Michael, for recapping all of that. I know for those of us who lived through the last go around, it was the regulations, but also the unique challenges that clients have when, running up against quick transitions. We don't have enough time, all of that stuff I'm sure is going to come back full force. But I am here in this section to talk about OFCCP compliance trends and new certification requirements. I think of OFCCP as an area that is one unique to government contractors generally, but also is an area that I think many contractors, your head starts to blow up when you start thinking about all of these compliance requirements. So Bill, we can go to the next slide. So I'm going to talk mainly about just broadly OFCCP jurisdictions so that everybody's on the same page to the extent you might be unfamiliar with it. And then in the later slides, I'm really going to talk about the last year, I call it the pandemic vortex, and in that period of time and what's been happening and what we think the trends are for the next year. So OFCCP really is, like I call it, the EEOC for government contractors plus, right? So it's all the same, a lot of the same stuff and overlap that the EEOC covers, but also some additional protected classes and things like that. So Executive Order 11246 really established, it's kind of not an exact mirror to Title VII, but it's that same idea, right? So the idea is that any contractor that's doing work for the federal government is not going to discriminate against employees on the basis of, race, gender, the added sexual orientation, gender identity, all of those kind of big ticket items. There's also Section 503 of the Rehabilitation Act of 1973 that really hits on disability discrimination and requires that contractors take affirmative action to prohibit that type of employment discrimination for contracts over $10,000. There aren't that many out there that don't pass that threshold, right? But might be some subcontractors, things like that, that don't hit that threshold. And then you've got the Vietnam Era Veterans Readjustment Assistance Act, VEVRA, of 1974, which was originally acted to protect returning veterans from the Vietnam War, but is now broader than that and covers many classes of veterans. So we've got this kind of broad OFCCP jurisdiction to take affirmative action to try to create a diverse workforce that's doing work on behalf of the federal government. And then the question becomes, okay, how do they enforce that? And they enforce that through a number of mechanisms. One, there are all of these kind of pre-employment, while you're hiring, how you have to recruit requirements that you might be familiar with. And there are also, for larger employers, over 50 employees with certain contractual thresholds, affirmative action plans. And the idea there is that you're assessing your workforce to try to figure out what you need to be doing to recruit, hire, and retain, promote different protected classes of individuals, really doing a self-assessment. And these processes and practices and evaluations and reviews that are done by OFCCP really are with that goal in mind. Employees can also complain to the OFCCP. So sometimes you will get complaints at the EEOC and the OFCCP, and the OFCCP will investigate those complaints to the extent they have jurisdiction given their purview. Next slide. So in 2021, we have a new director of the OFCCP under President Biden, Jenny Yang. Jenny Yang is formerly a plaintiff's attorney, and then she was appointed chair of the EEOC before she came to the OFCCP, there was a little bit of a break between the Obama administration and the Biden administration. And, you know, if you're really interested in what she was doing in between, there's a nice bio up on the OFCCP website, so you can kind of see what she'd been doing in the interim. But a lot of public service in her background since she came off the plaintiff's bar. And during her time at the EUC, and why I bring her really up in terms of what we can expect out of the OFCCP in the next few years, is that she really pushed this, you know, pay transparency and promoting pay data on the EEO-1 reports back in, you know, I think maybe 2018, maybe even a little sooner than that. And she really has a focus on pay equity and compensation discrimination. And so I think that is, you know, her background really speaks to, you know, what we can expect as far as how the OFCCP, not just the EEOC, but how the OFCCP might use data and really transforming some of what they're doing, you know, in investigations to data, you know, a lot of statistics, the way I think about it, and a lot of data and processing that data. So I think we can expect an increased focus and a continued focus on pay equity and compensation discrimination across protected classes, not just gender discrimination, and how agencies can use data that's being provided to them. And we'll talk about this on the next slides, but how really we can take that content and data and use that to tell them information about how contractors are hiring and whether they are kind of, you know, in sync with the OFCCP's goals and objectives. You probably see a poll up on your screen. So if you need CLE certification, make sure you get to that poll. And so we can go to the next slide. I think that's a good segue into the next slide. So despite the pandemic, there were a lot of activity and developments in 2020, 2021. Some of these go back to 2020. So my header here is not entirely accurate, but I think they're worth pointing out because in all of these cases, you know, this can lead to OFCCP non-compliance, which could be picked up in a review. So if you missed it, you have new self-identification forms for folks with disabilities. Make sure that you're using the right forms. The OFCCP is rather particular about the forms and the content that they want you to use when doing self-reporting and self-ID. So make sure that you go back and, you know, if you're advising clients, make sure that's part of what you're talking to them about. And if you're a contractor, make sure you're looking at what types of self-ID forms you're using under 11246 and under 503 of the Rehabilitation Act. They also implemented an early resolution procedure for conciliation agreements. So one of the big complaints coming out probably back to 2018 from contractors, and the OFCCP did this big evaluation regarding, you know, how it could really help contractors or what the missing link was, why they weren't getting through to folks. And one of the big pieces of this was like that contractors really felt like there were a lot of requirements and not a lot of guidance. So you'll see some of these new initiatives that we'll talk about today are really set forth with an aim of getting contractors informed and helping them come into compliance. And so this early resolution procedure, they've been in the investigations I've been involved in, have been pushing it you know, hard, frankly. They want to get cases, as all agencies do, you know, you see it with IGs now, they want to get these cases resolved early and they want to push for early conciliation agreements. And so it is not uncommon at a pretty early stage in my experience to see an OFCCP investigator put some sort of early resolution proposal on the table so that the investigation doesn't get drawn out if there's a way to resolve it early. The downside in my experience with this is that sometimes the request of the OFCCP for the early resolution is a little bit off base because we really haven't worked through the entire investigation. So, you know, it's a lot to me like mediation with a lot of imperfect information. And so sometimes each side is a little bit further apart than you might have seen in the past where we kind of get some more information. It doesn't mean that you can't reconcile later on in the investigation, but it does kind of, you know, in the investigations I've been involved in, it's been really a function of we can put this to bed now, and if we have to kind of pull back the curtain on all this other stuff, we will. But, this is the way to resolve it early. And there are specific procedures to that. So if you were involved in an OFCCP investigation and you get some sort of early resolution, it's a good idea to look at these reconciliation and conciliation procedures to understand what you're looking at and what your obligations are. I always get a lot of clients that will, if you're not familiar with the CSAL list, it's a list that comes out every year and says, hey, these are the contractors that have been pegged for investigations, and this is what we're really going to be investigating. And a number of clients will obviously don't always need counsel, don't want to spend a lot of money on counsel, which I completely understand, but will often call at the end and say, okay, now I'm getting this. What is this? What is this demand coming out of the OFCCP? So it's worth understanding what that means in terms of process. And it really is, if you are at the ERP stage or early in the investigation process, it's really an attempt to resolve it early. Not mandatory, doesn't mean they're automatically moving on to any sort of litigation. It's just it's an attempt to try to resolve it early before they have to spend resources on an in-depth investigation. It was also I think this is might be 2020 data, but it was the second highest year for monetary settlements, which is at 35.6 million, which is I think interesting given the year that we were in 2020. But I don't expect that to decrease given how quickly they're moving with some investigations. There was also a focus on Section 503 focused reviews. And if you're unfamiliar with a focused review, it basically means that the OFCCP takes one piece of the puzzle. So they might look at disability discrimination under Section 503, or they might look at BEVRA, or they might look at 11246, or they might look at certain policies, but they're taking a piece of it. And if you show up on the CSAL list, you'll see which type of review that you're expected to undergo. And there has been an increased focus on Section 503, or that disability discrimination. And they're going to look at things like how have you processed accommodations, how have you taken affirmative steps to recruit and retain individuals with disabilities, that kind of thing. So it's really focused on Section 503. And there are other types of focus reviews, obviously, that occur, but good to know that there's been kind of an uptick there. That should tell you that you should be checking and double checking that specific area of compliance. And there was also a high number of non-financial conciliation agreements, 75 in total that I could see and that was reported. And that what a non-financial conciliation agreement basically means is, we might not have found that you failed to hire a certain protected class like women, but which would lead to some monetary violations, but there are some things that you did wrong. You weren't using the right self-ID form. You didn't have the language right on your job postings. There are some things that you need to fix. And so there's kind of an increased focus on making sure you've got all that stuff in place, even if they don't find that you violated any of these requirements, and that would lead to a financial obligation. So something to note, that it's not just about whether you failed to hire a particular protected class or terminated at a greater rate or anything like that. It is about these other kind of non-monetary components that are in the regulations. Next slide. A couple of things to note is that there was, way back in, if you look way back to like 2019, the EEO1 was, everybody was gearing up to report pay data on the EEO1, right? So, and we called that component 2 data. And then there was a pause during the Trump administration, and basically said, we are not going to collect EEO1 component 2 data. We're going to basically, everything got paused. And now that's been rescinded. So what does that mean? That means that the OFCCP now plans to move forward and collect and use that previously collected component 2 data. So they weren't going to use component 2 data, even if it was reported. Now they are going to use component 2 data. And there, again, that goes back to what I was talking about in the, kind of this data analysis world that we live in, really using that reported data to give them insight into pay disparities across industries. My 2 cents on that, this is not, anything that I know of that's been reported, but my 2 cents is that they will then use that to target certain industries, certain job classes, things like that. So they can use that as part of their larger goal to combat pay discrimination in the broader government contracting workspace. Next slide. And then we had this, good, interesting, very interesting discussion about Executive Order 13950 that was issued by former President Trump. And that, if you might recall, a discussion on combating race and sex stereotyping. And the goal of that EO, according to the Trump administration, was to, advance equity across the federal government by making sure that each agency assesses whether its programs or policies perpetuate, and I'm just quoting this, systematic barriers to opportunities and benefits for people of color and other underserved groups. There was a lot of, there's some support for that. There was a lot of criticism about that and what it meant for things like training, discrimination, and harassment, what really the goal of that executive order was, how it would be implemented, and how it would be used. So not surprisingly, the Biden administration revoked that through EO 13985. So that's no longer on the table. Next slide. So one of the biggest ticket items that I wanted to talk about, because it is, because there's kind of this February 1st, 2022 deadline looming, but there was a directive in 2018 and the goal of this directive really was to make sure that employers were complying with their affirmative action requirements to the extent they were a government contractor and they met the employee count and jurisdictional thresholds in their contracts. And this was part of that larger effort to try to ensure that contractors were knowledgeable, that they were enforcing some of these compliance issues. And, it is not uncommon for a contractor to call me and I mentioned an AAP and it's just not, for whatever reason, it's not up front of mind. So this is really an attempt to try to get contractors to put the AAP, the affirmative action plan, up at the top of their list again. And so they implemented through Directive 2018-07 this affirmative action program verification initiative, which was really aimed at making sure that contractors are, annually preparing and implementing their AAPs. That doesn't mean you prepare it once and it goes in a box. You're supposed to do this annually. And a lot of contractors will, there are vendors out there that will do them for you. You can do them yourself, but it does require some statistical analysis of job groupings and classifications, protected classes, things like that. So involved in this process, they are ready to go now. They've developed a reporting program and things like that that's going live on February 1st, 2022. Contractors need to register for access to this portal. And the OFCCP will send emails to covered contractors in its jurisdiction when they have email information available. So they might not reach everyone. Don't depend on the email, basically. But if they have that email information, they will send out those emails and say, register for our portal. And then on March 31st, contractors will be able to utilize the certification feature in the portal to certify AAP compliance. If you might be saying, if you're a contractor, you have clients that are contractors, you might be saying, but we already kind of do this in SAM because we verify. There's a question in there that says, are you compliant? But there's no requirement to actually upload the AAP, and that, this OFCCP portal changes that. So by June 30th of this year, existing contractors have to certify whether they have developed and maintained an affirmative action program for each establishment and or functional unit as applicable. And so the practical implication of this is that there is kind of a run on these vendors and providers that are trying to get AAPs done. So I've been talking a lot to clients about making sure that they're prepared, that they're up to date, and to start doing it now, because I have a feeling that as we get into March and April, it's going to be very difficult to get an AAP completed in a timely manner. And so really looking at what you need to accomplish in order to meet these deadlines and certify compliance is going to be important. Next slide. Supply and service contractors who meet these thresholds for having AAPs have to use the portal. And then at this time, construction contractors who are not also supply and service contractors are not going to have to use the portal to certify AAP compliance. We expect that will be coming, but right now, as long as there's no crossover there, there's no requirement. And just because you certify AAP compliance doesn't exempt you from compliance evaluations. It's just another tool that they have then to collect data and to use that data. So you might still show up and pop up for compliance evaluation. Next slide. All right, and that brings us to the DOL enforcement update.
Thanks, Nicole. And actually, this is going to be for a few minutes, the Nicole Atala and Howard Wolf-Rada show, because we're going to just sort of have a conversational format here about things that we have seen in the recent past in terms of what DOL has been up to. And just so that you don't have too much of a break here, Nicole, I'm going to kick it right back to you, because we were talking the other day about some classification issues that you ran across in an enforcement action.
Yeah. Do you want to go to the next slide, Bill?
Oh, right.
Yeah. So Howard and I were talking the other day about this ongoing focus in FLSA investigations on classification issues. And in almost every DOL investigation I have under the Fair Labor Standards Act, there is a keen eye toward exempt, non-exempt classifications, particularly focused on those white collar exemptions, but really focusing on the salary basis test, making sure that employers are complying with that, and then making sure that someone that should be classified as non-exempt is truly classified as non-exempt, or that it's properly classified as an employee, not an independent contractor. And I think this is, we might have felt a little bit of a reprieve under the Trump administration with this, but the Biden administration and Biden's Department of Labor, if it's even appropriate to say that at this point, is really focused on classification again, and particularly the administrative exemption, white collar exemption, because, right now, $36,000 and change is not particularly high. So contractors are making some of those same old mistakes and saying, oh, whether you're a contractor or not, frankly, well, I'm paying people $37,000, $38,000 a year, why do we have a problem here? And it's really that duties test. It's that good old focus on that duties test and how difficult that is. And for government contractors, we'll talk about this in a minute, that are also have employee or contract subject to the Service Contract Act or Davis-Bacon Act, this first step of not classifying somebody correctly, if you kind of don't get this one right, it really has a lot of implications on minimum wage, service, whether a contract, whether employees get Service Contract Act wages and fringe benefits. So, whenever I'm talking to employers about this and trying to break down, and Howard, you probably have a similar experience with this, I'm always saying, you cannot get to SCA classification unless you've properly done FLSA classification. It's critical to that next step.
Right, and it's good that you mentioned classification. If we could go to the next slide here, please. One of the investigations that I had to face in quite a significant way was for a contractor that had food service operations in a number of locations around the country. And I bring this one up for a couple of reasons. Number one, if there's a complaint by an employee, sometimes that will start an investigation at one site, And then it'll percolate to other sites that have similar kinds of work, because they're going to ask you for all your contracts that you have and start digging into those. So in one case, this food service contractor was, the question arose about classification of positions, whether or not somebody was a food service worker versus a cook 1 versus a cook 2 versus a cashier versus a storekeeper versus a dishwasher. And the reason why I mention all of these classifications is because these were relatively small food service operations that had people doing multiple tasks. And when you have people doing multiple tasks, that sort of, unless you're able to clearly distinguish and keep time on the clock about what activity somebody's doing, you can find yourself in a situation where you're paying a much higher hourly wage to someone who's spending relatively small amount of time doing that more complicated work that would be devoted to more highly compensated employees. So that has been a problem for some of my clients in multiple kinds of venues. Another issue that has popped up, and I think Nicola's had some experience with this, is on our bullet point dealing with charging employees for benefit administration. Could you tell us a little bit about that?
Yeah, so I know there's a number of us that talk about these issues on a fairly regular basis. You know, you can cry for us later, but it used to be that you could essentially outsource your benefits administration, and under the SCA, you could basically say that if that benefit administrator charged a fee to say administer your 401k plan or administer your healthcare, that could all be basically divided and charged back against the health and welfare rates under the SCA. And there's been a kind of a shifting tide in this particular area. And I know there have been some discussions with the national office about what their position ultimately will be on this. But as more and more companies sort of developed to say, take on this benefits administration role, the Department of Labor is starting to look and say, well, is that really what the regulations were meant to do? Or is this just the contractor outsourcing their overhead, right? Is this just a cost of doing business? And you are finding a way to outsource it and call it benefits administration and use this part of the regulation, but it is not as clear, I think, as it used to be, that you are going to be insulated as the employer if you use benefits administration and they charge a fee back to your employees and count that against the health and welfare rate. So I don't think we have a final answer on how that's all going to play out, but it's something to keep in mind as an employer, or if you're advising employers, that if you're using these kind of third-party administrators that are also saying, hey, we will take all of the things that your HR department or your benefits people would otherwise have to do, we'll take care of all that for you and also administer your benefits. Those are the types of things that are coming under a little bit more scrutiny. So we're really watching that in the next year to see if there's any movement on the position of that. And I think it's going to be difficult, frankly, to make those determinations. You know, who gets to decide whether there is a component of it that's really the cost of doing business, or is actually benefits administration, right? I mean, I think there's going to be some questions there.
Yeah, and this ability to sort of take credit for the benefits administration costs and have that go against your H&W rate reminds me of a problem that's occurring, that goes back to the adoption of the sick leave executive order. I think federal contractors are relatively cognizant of the fact that they can no longer deduct sick leave expenses or include sick leave expenses as part of their H&W compliance, because that's why they have now or have had two different rates. But one place I've seen employers trip up is where there is a state mandated sick leave requirement that either duplicates or expands on, and that sort of thing. And the problem that presents, and this is true of sick leave, it's true of vacations and things like that. If a benefit is required by statute or by regulation or something like that, you can't take credit for that. And you can't,
Right.
you can't count that against your H&W compliance requirement. But, if you offer more sick leave than is required, then maybe you can count that. But, it's there, you can get into some messy areas when you're trying to figure out what you can and cannot count as satisfying your health and welfare requirement.
Not to mention the carryover requirements are sometimes different. The cap requirements are different in different states. So and as many of our clients are multi-jurisdictional employers, always no matter what we're talking about, right? It's layering them on top of each other to see, how all those puzzle pieces fit together. And sometimes that's extremely difficult to do. The other thing I would note on sick leave is, if you are involved in a Department of Labor investigation, I've had a couple of investigations this year where it seemed unclear to the investigator when the sick leave applied. And they weren't really looking at whether the FAR clause was in the contract. They were looking at that language on a wage determination that said, oh, the sick leave executive order is out there. So, just keep in mind that we still have to have that FAR clause in the contract for it to attach. And I think we're seeing fewer and fewer contracts where, it's those legacy contracts where it's not in there. But, sometimes contracting officers miss it or it doesn't get incorporated. And, so we're have that good old, can we fix it situation.
Well, and speaking of legacy, now we've got a new legacy requirement in the change of the minimum wage executive order.
Right.
So now that people gotten used to that one, now we got a new one. But anyway,
Yeah.
I want to shift gears though real quickly to something that you mentioned the other day about Davis-Bacon, and we jump to the next slide. And I'm kind of putting fast forward on this because we've got some other folks behind us that might want to talk for a few minutes. But you had mentioned about an issue that arose in the notion of the practice in the locality. I think it came up in the context of two different classifications of workers and how that played out.
Right. So, and this is not something new for this year, but I think there's kind of, I don't know if there's been some trainings on this for the Department of Labor, but I've seen it come up more in investigations this year where they're focused on not only what the wage determination says, but what the practice in the locality is as far as pay. And in my particular, the investigation I was working on, it came up in the context of carpenters. And this contractor had very carefully divided time out when carpentry was being performed. The records were really good. But the practice in the locality was that if they perform any type, the union practice in the locality was if they performed any type of carpenter work in that day, they got paid the full 8 hours or whatever they worked that day at the carpentry rate. So you couldn't divide the day. And I think it's more and more common that some contractors and subcontractors are not as in tune with the fact that they need to check for those labor practices in the locality, and that can really trip them up.
Well, thanks. I'm actually going to kind of put the cap on our presentation here and turn it over to Richard momentarily. But if anyone has questions about enforcement priorities or enforcement problems that you've encountered or wondering about, feel free to put them in the Q&A, and we'll try to address those, if not live, certainly by way of response later. Richard Arnholt, are you there?
Thanks, Howard. I am. Thanks very much to everyone for letting me join you today to talk about vaccine mandates. There's been, as you know, tremendous confusion over the past 3 months after President Biden, who stated that he'd lost patience with the unvaccinated, announced multiple mandates to try to increase the number of people vaccinated against COVID-19. While I think few disagree with the proposition that the vaccines are effective, at least in reducing the severity of COVID-19, it's not at all clear the federal government had the authority to issue those broad mandates. And after months of litigation and confusion, it appears for the most part that it is not. I'm going to briefly cover the background and requirements of the government contractor mandate, the status of challenges to the mandate, which is currently enjoined nationwide, and then briefly cover other potentially applicable vaccine and testing requirements and the status of those mandates. Next slide, please. So with regard to the background, as most of you are aware, on September 9th, President Biden announced 4 vaccine measures. First, the OSHA, the Department of Labor, would issue a vaccine and testing mandate applicable to companies with 100 or more employees. Second, CMS would issue a vaccine mandate applicable to Medicare and Medicaid certified facilities. Third, federal employees would be required to be vaccinated against COVID-19. And fourth, and most importantly for this presentation, the federal contractor mandate. In Executive Order 14042, the president stated that the Safer Federal Workforce Task Force would issue protocols for workplace safety guidance for contractors and subcontractors in order to reduce the spread of COVID-19. The task force, I'm not sure if you're aware, but it's an ad hoc body set up in January 2021. It has no regulatory authority, and it's made up of members of various agencies and White House offices, including OMB, GSA, CDC, and a couple of others. The president relied on a statute that was mentioned earlier for authority for this executive order, the Federal Property and Administrative Services Act. And we're going to talk about that a little bit more as the presentation goes on. There are significant differences between the mandates. Some allow for a testing option, others do not, and other differences as well. Prior to the issuance of this task force guidance, the executive order directed the director of OMB to determine whether or not the guidance would promote economy and efficiency in federal contracting. Now, that's the standard that the White House believed needed to be met in order to issue the guidance under the authority given to the president in the Property Act. I'll refer to the Federal Property Administrative Services Act as just the Property Act from now on. The determination was made in a perfunctory 1-sentence notice in the Federal Register that the guidance would reduce attrition and therefore make government contractors more efficient, and the task force guidelines were published. The notice that the OMB director issued was later updated in November after court challenges were filed. It was updated with a more lengthy explanation of how this would make contractors more efficient by reducing the number of employees who would be out on sick leave. It mentioned that a number of private contractors or private companies had implemented vaccine mandates, including Walmart and others. The government believed if it was good for those private companies, that it was appropriate for the contractor workforce, even though those employees didn't work for the government. Interestingly, I think importantly, in sort of showing the philosophical split between government officials and private businesses, there's no explanation as to why the government believed private companies would not have already implemented vaccine mandates if they really made those companies more efficient and therefore presumably more profitable. I think the explanation most likely is that those companies believe vaccine mandates would cause significant attrition, something that they couldn't afford in an incredibly tight labor market that's already left many of those companies understaffed. So the applicability, it's incredibly broad, applicable to contracts and contract-like instruments like cooperative research and development agreements or other transactions agreements, must be flowed down to subcontracts unless solely for the provision of products. It does not apply to contracts for goods. It applies to contracts for services, construction or leasehold interests in real property, a couple of other types of contracts, concessions, and so on. The executive order does not apply to grants, doesn't apply to contracts below the simplified acquisition threshold, or to contracts outside the US or its outlying areas. But it encourages agencies, interestingly, to apply it to contracts even where not required. The requirements were to be implemented and applicable to new contracts, as well as options and extensions issued after October 15th, 2021. So what did the mandate require? Now, most people at government contractors have been through a tremendous uproar over the past few months trying to implement these requirements, then dealing with the delay and the deadline for these requirements being implemented, and then dealing with injunctions and so on. But I'm sure many of you were familiar with the most important of the 3 requirements under the guidelines, and that is the mandatory vaccination for employees. It's applicable to 3 buckets of employees and is remarkably broad. First, it applies to employees working on the covered contract. Second, it's applicable to employees working in connection with a covered contract. And that would be HR, legal, accounting. And I think those are the examples actually given by the task force guidance. But the broadest category of employees who have to be vaccinated are those employees in a building or facility where one or more employees in the first two categories is likely to be present during the period of performance of the covered contract, irrespective of whether those employees have anything to do with the government contracting business. So as an example, let's say you have an accountant who works in connection with the government contract because he or she is responsible for processing all of the invoices and getting them submitted. That accountant spends 2 weeks at the company headquarters where no one does any government contract work whatsoever, directly or indirectly, just at the end of the fiscal year, closing out the books. Everybody, because of that accountant's presence in the corporate headquarters for those 2 weeks, everyone in that corporate headquarters, regardless of their connection with the government contracting business, would have to be vaccinated under these rules. It's really, really extraordinary. And you can see, and I excuse the pun, but you can see how very easily an entire company could get infected with this mandate, even if only very limited portions of the company actually engage in government contracting. The guidance also requires employees who work 100% remotely to be vaccinated, even though the stated purpose of the guidance is to reduce the spread of COVID in the workplace and to reduce attrition. There's also no exception for people who work outside. As federal law requires, there were exceptions in the vaccine mandate for employees who are entitled to religious or medical accommodations. And originally, the vaccine mandate had to be implemented and all employees had to be fully vaccinated by December 8th. And that left very little time between the October 15th date when this went live and the time that contractors had this incorporated into their agreements and the date on which the employees had to be fully vaccinated, which means 2 weeks after the last required vaccine dose. So for the Moderna vaccine, for example, those 2 doses, I think, have to be spread 4 weeks apart. For Pfizer, 3 weeks apart. So that meant the last vaccine dose had to be received somewhere around November 24th. That means the first vaccine dose for Moderna had to be given sometime around late October, early November. Now, the other 2 requirements, much less contentious, I think, than the vaccine requirement, are a masking requirement for unvaccinated people, as well as vaccinated people at the work site in areas of higher substantial community transmission. If you've looked at the CMS map about transmission across the country, it's most of the country. Also, companies had to appoint a COVID workplace safety coordinator who's responsible for things like confirming vaccination status, signage, and so on. One of the things that was not clear when this was issued, an executive order or the guidance or the FAR provision that I'll talk about in a minute, and still isn't clear, is what the penalties would be for noncompliance. There's no certification or representation required. There's language in the FAQs that the task force has issued that indicates that the contracting officers are supposed to work cooperatively with contractors where employees are refusing to comply with the vaccine mandate. But I think in situations where contractors refuse to comply or misled the government about their compliance with these requirements, I think termination is probably possible. Suspension and debarment if the violations were willful and the company put others at risk of infection, and perhaps even False Claims Act suits. Again, it's not clear, and the government never really issued guidance on what those penalties could be. The requirement wasn't immediately effective when the guidance was issued. The executive order required that the FAR Council amend the FAR to require the inclusion of these requirements and to take initial steps by October 8th to implement direction to agencies. So in accordance with that, that mandate, the FAR Council issued a deviation, FAR 52223-99, on September 30th. That provision just requires compliance with the guidance, including the facts. Interestingly, not just as it appeared at the time, but as amended during the performance of the contract. So sort of an evergreen provision. So the task force, which did in fact issue updates to the facts and other sections of the guidance, could continue to change the guidance over the course of a year or two during your company's contract performance. And that company would have to continually adjust to whatever those new workplace safety guidelines were. I think quite challenging, and made it difficult for companies to gauge what the potential cost of compliance with this requirement might be. It also mandated flow down of the provision to subcontracts for services. Interestingly, that's very different language than the executive order used for the exception. In the executive order, the provision was supposed to be flowed down until you got to a subcontract solely for products. Now, I don't know whether the FAR Council felt that was just an unworkable provision solely for products, because even product contracts have warranties, training, other support services that they're not significant, but they're a portion of the contract. So, but I think the language solely for or subcontracts for services could be interpreted to mean subcontracts that were primarily for services. Agencies issued deviation clauses in the following days that mirrored the FAR language. There were some differences, though, in implementation. For example, the GSA announced in its deviation memo that it would be administratively too challenging to determine which of its federal supply schedule contracts were solely for products. And so it was going to apply the vaccine mandate to every single one of its federal supply schedules. All of these commercial, these agreements with commercial companies made it quite challenging, I think, for them. The VA, in contrast, for the federal supply schedule contracts that it administers, announced that it would only apply the vaccine mandate to its schedules for products, that's durable medical equipment and pharmaceutical products. Sorry, it would not apply to those FSS contracts for products, but would only apply the vaccine mandate to its FSS contracts for services. And so the GSA and the VA started amending their schedules. Other agencies started amending their contracts, updating solicitations, and almost immediately after the deviation clauses were issued, contracting officers started pushing contractors to amend existing contracts, even in the absence of options being exercised or extensions. And they presented contractors with bilateral modifications, suggesting very strongly that contractors had to sign them. Well, that wasn't required by the EO or the guidance. As I said, many contractors suggested otherwise. Also, a lot of agencies were including, without really pointing to it, waiver and release language, saying that contractors couldn't file requests for equitable adjustments for any costs flowing out of compliance with these requirements. Those, of course, weren't required, and most contractors pushed back, but it really highlights the importance of reading every modification you get from the government. And interestingly, OMB and a couple of agencies said very publicly that contractors would be able to submit REAs for costs resulting from compliance with the vaccine mandates. But they also said they didn't expect there to be any costs, because these vaccine mandates would create a sort of efficiency savings and would lower the cost of performance for contractors. Again, sort of demonstrating that disconnect between the government philosophy about these types of things and the philosophy of private businesses, who are much closer to the employees the government is trying to regulate, and probably understand a lot better what those individual employees' situations are. So, do contractors have to comply with the contractor vaccine mandates? No, not right now. In October and November, multiple states filed suit in district courts across the country. In total, 25 states filed challenges in Florida, Texas, Missouri, Kentucky, Georgia, and Louisiana. In every single one of those cases, the courts issued the challengers preliminary injunctions. Although the courts had different analysis as about why it was issuing those preliminary injunctions, why the states were likely to succeed in showing that the executive order was illegal. The states also differed with regard to the scope of those injunctions. Now, 5 out of 6 of the courts held that the president likely did not have this authority under the Federal Property and Administrative Services Act of 1949. That statute was issued after World War II, when the government wound up with significant surpluses due to duplicative contracting and sort of an overall lack of central organization and management in our procurement system. The whole purpose of this act was to give the president the authority to better direct procurement operations across the government. It authorizes the president to ensure that the government has an economical and efficient procurement system. DOJ has a different interpretation of the Property Act that has been rejected by almost every court that's looked at it over the past 3 months. DOJ believes it authorizes the president to use necessary measures to procure economical and efficient non-personal services. Very distinct, sort of a reordering of the words, but a very distinct, different result. This is not the first time that that a district court has rejected broad interpretation of the authority under the Property Act. In 2016, there was a challenge brought by the Association of Builders and Contractors in Texas to the Fair Pay and Safe Workplaces executive order issued by President Obama, as well as the implementing FAR provision in the Department of Labor regulations. The district court judge in Texas held that the public disclosure and disqualification requirements being imposed on federal contractors and subcontractors are nowhere found in or authorized by the statute on which the executive order, FAR rule, and DOL guidance relies, the Federal Property and Administrative Services Act. Now, that case ultimately wasn't litigated to the end because the rule was stricken by Congress using the Congressional Review Act. So, I think now we're going to get the guidance that ultimately we didn't get from the courts then. So, of all the 6 cases in which preliminary injunctions were issued, only one, the injunction issued by the Middle District of Georgia, is nationwide. All the others are limited to the plaintiff states. Some enjoining the government from enforcing this against just state entities, others limiting the government from enforcing this against any contractor or subcontractor in those states. But Georgia enjoined it nationwide primarily because an intervener in that case, interestingly, again, the Association of Builders and Contractors, it was the nationwide entity that had intervened, as well as the Georgia entity. But the nationwide entity had tens of thousands of members across the country, and there were declarations introduced that stated that all of them will be contracting regularly with the federal government, and so if they were not already subject to the mandate, would certainly be soon. And the judge felt that he couldn't grant adequate relief to the plaintiffs and the interveners unless the vaccine mandate was enjoined across the country. That injunction was appealed, and the Department of Justice asked the 11th Circuit for a stay pending the appeal. The 11th Circuit denied that request, saying that the government couldn't show that it would suffer irreparable injury if this injunction wasn't stayed. Also, the injunction issued by the court in Kentucky that applied to Kentucky, Ohio, and Tennessee was appealed to the 6th Circuit, and the 6th Circuit, in a pretty lengthy 2-1 decision, denied DOJ's request to stay the injunction pending the appeal, finding that DOJ was very unlikely to succeed on the merits of its arguments that the parties lacked standing, or that the Federal Property and Administrative Services Act allowed the president to implement this sort of broad public health measure through this back door of the Federal Property and Administrative Services Act. I think for now, the government contractor mandate is mostly dead, unless and until the 11th Circuit reverses the Middle District of Georgia, or there's some other sort of emergency relief sought from the Supreme Court. The 11th Circuit has set out its briefing schedule. It's set out an expedited schedule. The briefing, I think, is supposed to be complete in February, and oral argument, I believe, is expected to be held on April 4th. So we'll likely not hear anything that will affect the requirement that you comply with the federal contractor mandate until, I think, mid or late April. There are some other mandates that are potentially applicable to government contractors, or were potentially applicable to government contractors. First, the OSHA vaccine and testing emergency temporary standard. That requirement was applicable to companies with 100 or more employees. As soon as OSHA issued that ETS, it was challenged in circuit courts across the country. And the day after it was published in the Federal Register, that it was enjoined nationwide by the 5th Circuit Court of Appeals. Eventually, all those circuit court challenges were consolidated at the Sixth Circuit, which dissolved the preliminary injunction in a 2-1 decision on December 17th. That was immediately taken up to the Supreme Court. Justice Kavanaugh has responsibility for emergency appeals from the Sixth Circuit. He did not decide the matter, though. He referred it to the full court that had oral argument on January 7th. The Supreme Court on January 13th stayed agency action, essentially reinstating the preliminary injunction and sending it back to the district court. The reason that the Supreme Court put the injunction back in place was primarily because nothing in OSHA's statute authorized it to issue a public health measure that had such a significant impact, that basically requiring 84 million Americans to either be vaccinated or comply with this testing mandate. The Supreme Court, I think thought it very important that this wasn't really a workplace safety measure. They were requiring employees to have an irreversible medical procedure that protected them, not just from a danger at work, but from a danger more generally, a danger of life. They could get infected at the supermarket, they could get infected at a PTA meeting. It wasn't a workplace specific risk. The Supreme Court did, however, say that if OSHA had tailored that vaccination and testing requirement more narrowly to industries that faced unusual risk of COVID-19 infection and spread, that may be within their authority. So I think after the Supreme Court decision, we may well see OSHA take another run at it, maybe limit the vaccine and testing mandate to industries where people are very closely packed together, meat packing, poultry, and so on, or where individuals are dealing with, developing vaccines or things like that, or dealing with COVID, the COVID virus itself. So we'll see. One of the other main mandates, the CMS rule that required healthcare workers be vaccinated as a condition of participation in Medicare and Medicaid, was enjoined in half the states in December and then later enjoined nationwide by a district court in Louisiana. That was appealed by, those injunctions were appealed by the Department of Justice and emergency action of the Supreme Court. That case was also heard on January 7th. The Supreme Court upheld that requirement. Different statutes give the Secretary of HHS and CMS the authority to set the conditions of participation for different types of healthcare facilities like hospitals, nursing homes, skilled nursing facilities, and so on. And given that it's a healthcare specific setting and they have the right to set the conditions of participation, the Supreme Court thought that was an appropriate use of their authority. So that CMS interim final rule is in place, does apply, and CMS is in the process of requiring 100% compliance, which I think has to be achieved by middle of February or late February. Then the federal employee vaccine mandate, it's really not been a good couple of months, by the way, for the Department of Justice. I don't think they were handed a very strong group of arguments by the president, but they've not done well with the challenges so far. The federal employee vaccine mandate was enjoined by the Southern District of Texas just this past Friday. The court in Texas had applied the same sort of reasoning used in the OSHA case by the Supreme Court. This isn't a workplace mandate, but rather a public health measure, and nothing in the statutes the president cited or in Article 2, the president's inherent authority under the Constitution, authorizes him to require a public health mandate of this scope. So we'll see what happens here. I'm sure DOJ will appeal immediately to the Fifth Circuit. It's a very conservative appellate court, as you probably know. And I doubt the Fifth Circuit will receive the DOJ's arguments very well, but you never know. We'll see. Other mandates include state mandates, particularly in the healthcare space. So far, the Supreme Court's declined to intervene on grant sort of interim relief in challenges to those mandates. For example, in New York, that require healthcare workers to be vaccinated. And the country has a pretty long and established history of allowing states under their general police powers to mandate vaccinations. Most people have probably heard of the Supreme Court case from 1905 involving a challenge to a Massachusetts statute that allowed cities and municipalities to require their citizens be vaccinated against smallpox. So, the states have that authority of the general police powers, no such general police power for the federal government. And so the Supreme Court and the other courts have been looking at authority under particular statutes to try to find whether the government can do that. Also, just in the past couple of days, a border mandate has gone into effect that requires all truckers who go north or south across our Mexico and Canadian borders to show proof of vaccination. If you thought it was difficult to get fruits and vegetables at the store last week, just wait. I think this is going to significantly exacerbate our supply chain problems. And then finally, I think the one that's most problematic or challenging for government contractors is that their government facility or building workplace requirements. The government in many agencies are requiring that individuals entering government facilities either certify their vaccination status to show that they are vaccinated or show proof of a negative COVID test from the prior 72 hours. In some cases, they're requiring a negative COVID test from the prior week for contractors. So it's not clear how long those workplace measures will remain in place, given that even the federal employee mandate's now been enjoined. That said, there's a statement on the Safer Federal Workforce Task Force website that says the testing and masking requirements of the federal employee safety guidelines are still in effect, even though the vaccination mandate isn't. For contractors that have difficulty meeting those vaccination or testing requirements, particularly given the dearth of tests that we're experiencing right now, I think you could argue it's a contract change and seek compensation for delaying costs of recruiting and other costs. For example, there are costs of paying your employees for their time to go and get vaccinated or go and get tested. Interestingly, the excusable delay provision in the FAR 52-249-14 excuses delays due to epidemics, and perhaps that applies to measures taken in response to epidemics and pandemics. And again, as I said, it's not clear courts are going to allow the government to impose these vaccination and testing requirements, given the holdings in some of the other vaccine mandate cases. What's also not clear is whether the government could continue to operate if it imposes these requirements. In some states, the working age population, 18 to 60, 65, has a vaccination rate of close to 50%. For the entire population across the country, the adult population, 18 to 100, that vaccination number is much higher, 70, 75%. But that's primarily because people over 65 and over have a very, very high rate of vaccination because this disease is particularly dangerous to them, as probably most diseases are. So I don't know if the government could continue to operate if it enforced these vaccine mandates strictly. They're going to have contractors, or some of them are expected to experience 20 to 30% attrition if they imposed these vaccine mandates very strictly, and they probably couldn't satisfy their contractual requirements if they lost that many employees. So that may ultimately be the deciding factor for government contractors, whether or not they can perform the work and comply with these vaccine and testing requirements at the individual facility levels. So in conclusion, at the federal level, only the CMS mandate is on firm ground. Doubtful the government contractor mandate's coming back. I don't think you'll hear any news about it until April, even if it does come back. The OSHA mandate is unlikely to come back in its current form, but may come back in a more limited industry-specific form. And the federal employee mandate is going to wind its way through the courts. We'll see what happens ultimately with that. Look out for facility entry requirements being probably, I think, the biggest challenge government contractors are facing. So thanks very much for your attention. And I'm going to pass it on now to my colleagues to talk about some recent case developments. Thanks.
Thanks, Richard. I see it's the hour is drawing nigh, so I will give you the instant version of this, of notable cases. But before I do, something Richard said about the Fair Pay Safe Workplaces being stricken by the Congressional Review Act back in 2017. For those of you in the DC area, I get a sense that that's coming back in some shape or form, because there was an article in the Washington Post over the weekend extolling the underlying factual premise for why Fair Pay and Safe Workplaces is necessary. My sense is that's a trial balloon put out by the administration. So let us assume that that is not dead and that they're going to try to find some way to bring that back. So let's go to the next slide. And in the interest of time, let's skip all the OFCCP stuff. and go to Davis-Bacon Act. Basically, there were three interesting cases of note under the Davis-Bacon Act this year. The first one, the IBEW Local 113 case, talked about the intersection of arbitration and the Davis-Bacon Act. The 10th Circuit went in, had a very nice summary of the Davis-Bacon Act's regulatory scheme and enforcement mechanism, and ultimately came out and concluded that classification under the Davis-Bacon Act, whether a worker is a laborer or a bricklayer or a mason or whatever, those are issues that are not arbitrable, but instead must be resolved by the Department of Labor under the Davis-Bacon Act. So that's a very nice case in case you're dealing with any kind of arbitration issues. The next case is again another IBEW Local 98 case. I clearly don't have time to go into this one the way I'd like, but this is a case that deals with the intersection of the False Claims Act and the Davis-Bacon Act, and particularly deals with how damages can be calculated. Basically, a contractor had a contract with SEPTA for track and signal improvements for the public transit system in the Philadelphia area, and had Davis-Bacon related act clauses of wage determinations. Department of Labor investigated, didn't find much, but the union filed a qui-tam action back in 2007. 2009. The case languished in the court for years. The government never intervened in the case. The district court tried to refer the matter to Department of Labor to deal with the Davis-Bacon Act issues. DOL declined. At the end of the day, though, the case got referred back to a special master who found certification violations based on the certified payrolls and levied some pretty hefty penalties and fines on the contractor. And the Third Circuit affirmed and found that the false certifications under the Davis-Bacon Act, that the certifications were a condition of payment in a post-Escobar world. And the contractor had knowledge of its falsity and therefore was appropriate. But the real kicker here was how damages were computed. The court approved a burden shifting analysis that had been used primarily in FLSA cases and with some discussion in the Davis-Bacon Act context, but I believe this is the first time that it was really applied to a False Claims Act matter. So that case is definitely worth a good read for calculation of Davis-Bacon Act FCA-based damages. Finally, the last of the three Davis-Bacon Act cases would be United States versus Estepa. This is a nice cautionary tale to tell your clients that if they do not comply with the Davis-Bacon Act, they can go to jail, because that's exactly what happened here. So that's a very nice cautionary tale to know. And then finally, let's go to the next slide. And let's go one more. Basically, it's Gemini Tech. Another one too. Gemini Tech dealing with Service Contract Act stuff. It arises in a bid protest context because I had a number of clients lately who look at their competitors' bids and say there's no way that they're complying with the Service Contract Act based on their firm fixed price that they're offering. So there must be an SCA violation here. However, GAO, in its infinite wisdom, has said no. And basically, where a firm offers hourly rates below those specified in an SCA wage determination, that firm is nonetheless eligible for a contract award, provided the proposal does not evidence intent to violate the SCA, and the firm is otherwise determined to be responsible. In other words, hear no evil, see no evil. So the time is nigh. I think that's all we'll talk about today for cases of note, but I do recommend that you read all of them. There wasn't a whole lot of bombshell decisions in the past year, but I do fully expect that in the year to come, we're going to start to see some, especially with the change of administration going forward. So check this space, doing Alan's job, check this space next year. I'm sure we're going to have lots more to talk about. So with that, who do I turn it over to now?
I'll take it. Thank you, Michael. Nicole, Richard, Howard, thank you very much for an excellent set of presentations. It covered a lot of area. Folks who are tracking this, and we'll spend a little bit more time on this in the statute executive orders, but President has issued 77 executive orders in 2021, the most of any president's first year term. Labor and employment was a huge area for that, and I would expect to see a lot more of the rules that were required by these executive orders that were addressed here to come out early next year. So we will certainly have this panel back next year, and we may even do something different and try to touch on some of these important issues, particularly around the vaccinations and some of the implementing executive orders before next year as well. So follow the PubK group, subscribe to the newsletters, and watch for additional information about this area and other areas as we go forward. So a big thanks to our panel here for all of the work that they've done and compiling the information and making the presentations available. As a reminder, because you've asked, all the slides will be made available. We'll send those out. We'll send a notice out probably in a week or so that the slides are available and when you can download them and how long they'll be available. Let me again thank our event sponsors for their support on these next two slides. Very pleased with the support that we have from them, and I encourage you to look at their capabilities during the course of the year. That concludes our session for today. I look forward to seeing you all the next session tomorrow. Have a great day.